Well, we're delighted to see people in the room. We're delighted, and we hope that there are many people online. Apologies to those in the room and apologies to the people online. I used this expression 5 minutes ago. To err is human. To muck things up completely takes a bunch of middle-aged men, or rather old men, and a computer. And the IT inevitably mucks us up every time. But anyway, my name is Mark Thomas. I'm a past chairman, and the reason I'm doing the introductions is because the current chairman, James Richardson, is our speaker tonight. So we thought it inappropriate for him to introduce himself. So just about the Thames Valley branch of the Institute of Arbitrators and about the Institute of Arbitrators. We are based in the Thames Valley. We have 270 odd members in the Thames Valley. And although we're called the Institute of Arbitrators, most of our members are not arbitrators, but they're involved with dispute resolution in different forms. So it might be mediation, it might be expert witness, it might be adjudication, and some of us are actually arbitrators as well. Next slide. And we cover roughly Berks, Bucks and Oxon, and we move our events around the 3 counties. So we go to Milton Keynes, as indeed our next meeting is going to be in Milton Keynes, sometimes Reading, sometimes Oxford, but more often than not, we'd like to go for Maidenhead because more of our members are down at the south part of the 3 counties. Our next meeting is going to be in Milton Keynes at the offices of EMW Solicitors, and it's going to be on the use of AI in dispute resolution. So something not construction-based, but right across all areas of dispute resolution. And I'm looking forward to that because it's something which is moving at a great pace. And I'd encourage people to either be online or to come to that event in MK in 3 weeks' time. Next slide. Following that, the following month, so that's another 3 weeks after that, we're going to hold the first branch dinner that we've had for 6 years. We were hoping to hold them more frequently. We held a very successful one in 2019, and then a little thing called COVID got in the way. So it's going to be at Malmaison in Reading. I can tell you that it's not going to be ridiculously expensive. It's £60 per head. And then for younger members, we're going to subsidise it, so it'll only be £30 per head. And it's an opportunity to mix with and have a social evening with other members and guests. We're certainly throwing it open to guests. And our main speaker is going to be Nerys Jefford, who is a wonderful TCC judge who's going to speak for a few minutes that evening. And then we turn to this evening. The speaker this evening is your branch chairman, James Richardson. James used to work for me, but fortunately he left, which is great. But he saw the light and I saw the light. But no, I know quite a lot about this paper because he used it as the basis of his MSc project at King's a couple of years ago, and it is a hot topic, and it's a topic that constantly changes. So I won't go on about all the qualifications which he has, for he's such a young man, but I think it's going to be a fascinating talk. And I would finally, before asking James to take the floor, for anybody online, if you have questions, we'll take questions at the end. If you'd like to use the Q&A box in the Zoom facility, we'll take those questions both in the room and online at the end of this evening's meeting. So without further ado, I'll swap seats with James, and we'll now load the slides for his talk, and we'll be back with you in about a minute. James, it's all yours.
Okay.
Okay, you just get them up on there, if that's, or do you want me to do it?
Yeah.
You do that one, Mark. You let me know when we're up and running, and Eddie, am I broadly somewhere that they can see me online?
Yeah.
Lovely, thank you. And good evening to those in the room as well. Thank you very much for making the effort to actually join us in the room. We do appreciate it. It's great to have some people here as well as the large number we have online. So really excited to be speaking tonight. And I think that now that we've got the technical issues out of the way, we can do the easy bit and run through the presentation. So if we're there, I'll just flick down to the next page and give a brief introduction on what I'm going to talk about tonight. Topic I've been given is, have the payment notices, have the courts got it wrong? as Mark says, this is based on my dissertation and then an article which I've written to be published shortly. Mark gave the suggestion of the title, Have the Courts Got It Wrong? It's a bit punchy, but I thought I will give it a go because I actually think they may well have done, and I'm going to set out my case as to why. I've never struggled giving an opinion before, so there's no particular reason I should start now. So what we're going to do is we're going to have a very brief high-level review of the current position, just as a snapshot, before walking through the case law to understand how we got there. And that's really the aim of start with this is where we are, but how have we ended up where we are now? And understanding how that aligns with previous authority and how we feel about that. Before we have a quick look at the very end on the role of additional requirements which may be included within a contract. So, as I'm sure most in the room will be familiar with, the Construction Act requires all notices, and when I say all 4 types of notices, I'm talking about applications for payments, payment notices, default payment notices, as they're colloquially called, or a contractor's notice or payee's notice in default of a payment notice, and a pay less notice. And broadly, all 4 of those notices need to do 2 things. They need to specify the sum considered to be due at the due date, and they need to specify the basis on which that sum was calculated, which all seems straightforward enough. Yet, in Advance and an ESCA, we have been given 9 tools or methods of interpreting these contractual notices. Some of which we're going to run through will be very familiar with the leading House of Lords authority, which is Mannai, and others have been developed since the introduction of what we might colloquially call smash and grab adjudications, or more properly notified sum adjudications. And because of that introduction, there seems to have been a real increase in these tests, perhaps, one might suggest, as a result of the court's dislike for smash and grabs. But before we do that, we're going to look at 4 phases of the case law to understand how we've arrived at the current position. And we're going to start with very briefly looking at the position, the common law position prior to the leading case of Mannai. We'll then look at Mannai and how that changed the method of interpreting contractual notices, and that remains the leading House of Lords authority, before coming on to review how the courts have actually approached payment notices under the Housing Grants Act, or the Construction Act, as I'm going to call it for this evening. So historically, the courts adopted an extremely strict approach to construing notices under the contract. In Cadbury and Martinez, we've got Lord Denman saying that if a notice is not in accordance with the provisions of the contract, it must be invalid. More recently, Bingham in Delta Vale stated that a notice is invalid unless it gives the precise notice which the contract requires. And this comes from a very simple idea, which is that you don't have the right to give a notice unless that right is given under the contract, and that notices will have a unilateral effect, and therefore the provisions of the contract must be strictly adhered to. To illustrate this in a bit more detail, we've got Sidebotham and Holland, and in this case, the tenant was able to give a notice to quit on the 18th of May, essentially. It was the 3rd year of the lease, or the anniversary thereof, but it was the 18th of May, 1894. The notice was given. It was given in time. There was no question about it being given late. It was given in time. But on that notice, they stated that they would quit on the 19th of May. It was held that the notice was invalid. And we've got Smith LJ stating here that although this argument was technical and without merit, he held that the unceremonious technicality must prevail. So the notice was given in time. There was no issues with the form of the notice. There was a minor slip in the date on which the notice would take effect, and that slip was deemed to render the notice entirely invalid. And if I can put that in the context of a payment notice, we might think that where a notice has to specify the due date or the sum considered at the due date, if this approach was applied, if you got the due date wrong by a day on your notice, it would appear that under the old approach, which is no longer current, that notice would be invalid. And I've got one more quotation here, which really just hammers home the point and the court's philosophy, with Lord Green stating that the desire to aid people unfortunate enough to make slips is a temptation which must be resisted. And then we come on to Mannai, or Mannai and Eagle Star Life Assurance. Now, the facts in this case are very similar to the case we looked at a few moments ago. The termination of the lease the tenant was able to terminate that lease by a notice stating that they would terminate it on the 13th of January 1995, nearly 100 years later to Sydbotham in Holland. The notice was given, but it said that the lease would be terminated a day early, on the 12th of January that year. We will all be aware of the similarity, and applying that previous authority, you would expect the notice to be deemed invalid. And that's where we got a split decision in the House of Lords, and the minority kept with the previous authority. They held that although holding the notice to be invalid will result in hardship, the notice giver will only have himself to blame. And that should be no surprise, because it's entirely consistent with what came before. What might have been a surprise was the judgment of the majority. And Lord Stein stated, and he set out the leading judgment, or the leading rationale in that judgment, and he stated that the test is how a reasonable recipient would have understood the notice. And that this means that the court can ignore immaterial errors which would not have misled the reasonable recipient. Now, I'm hoping, and I'm sure very many of us are familiar with this reasonable recipient test. This is the origin of the reasonable recipient test, and this is the last and most recent House of Lords authority on that point. So we'll come on to how it's been applied, but this is still very much good law. We also get, in this case, a little bit of an explanation as to how we are to apply that reasonable recipient test. For example, we're told that a reasonable recipient would have the terms of the contract in the forefront of his mind. There's a very recent case which we'll touch on at the end of this, just bring this right up to date, where it's clear in the submissions that neither of the parties had a clue what the terms of the contract were. And that was actually possibly in no part of fault of their own, because it was one of these situations where the scheme was spliced into the contract, and it took the judge a considerable number of pages to work out what the terms of that contract were. So although the parties themselves subjectively will not have these terms in the forefront of their mind very often, the reasonable recipient, the test we are to apply, does. And I think that's really important. We're also told that the court should be cognizant of the relative objective contextual setting. And again, in this very recent case, they talk about the way payment applications and notices are usually held in the industry, or handled in the industry, which I think is a really interesting point, because if we look at the way things are commonly done, does that colour the reasonable recipient and how the reasonable recipient would understand a notice that's given to them? And then finally, a commercial person is hostile to technical interpretations. And I think that's important to note, because we're going to come on to see some very technical interpretations a bit later on. And just one thing to clear up before we go any further. There was a suggestion, or the suggestion was dealt with in this case, that because this case pertained to a notice in a lease, perhaps they were different to notices that might be given under other types of contracts. And we're told that that's not the case at all, because they belong to a general class of unilateral notice, which payment notices, application for payments are squarely within. And also we can look at other cases and how they're dealt with currently and to see perhaps some inconsistencies there. Now, notices under the 1996 Act were not really the subject of a great amount of litigation and were fairly disinteresting. Payment notices in particular got hardly any litigation. In fact, I found none in my research. What I did find is Lord Hoffman stating that serving a payment notice seemed to have no consequence and that there was no penalty for not doing so. This is under the old 96 Act before we had the 2009 amendments. So the litigation that did happen in this period was focused squarely on withholding notices and their validity or otherwise. And we do get a couple of cases, and these cases really just pick up the themes of Mannai and apply the same principles. So in what we've got here, VHE, we've got Hicks stating that this was a bit interesting because the party had tried to argue that a submission in an adjudication could be a withholding notice. It couldn't, they found out, they held, which seems entirely sensible. But the notice didn't need to be particularly formal or bear a particular label. So we're continuing that as long as the party can understand what they're being given, or a reasonable recipient would understand what they're being given, the notice is going to be held to be valid. And Kirkham has given us in Thomas Vale a quote which has been echoed in later cases, and we will see that a fine textual analysis would be inappropriate and rejected what was called artificial and contrived arguments. So what we're seeing is something that's really, really consistent with the approach in Mannai, in my opinion, not to be too rigorous, not to take artificial or contrived points, but to just ask ourselves the question, would the person receiving this notice reasonably have understood it? And the same approach was adopted in Alston. We then come on to 2009, amendments to the Housing Grants Act in the Local Democracy Act, combined we'll call those the Construction Act, which really increased the importance of the notified sum. You get smash and grab adjudications. ISG and CVIC is just but one example of cases which hammered home the point, which was finally settled in S&T and Grove. But even today, we still get smash and grab adjudications, and they're still a very powerful tool for a payee. And as a consequence of that, the importance of a payment notice and whether or not it's valid, and an application for payment in particular and whether or not it's valid, was again heightened. And as a result, we see a great increase in the litigation. And some would suggest that we see a proliferation of tests, perhaps designed, one might argue, to produce clarity or ensure clarity in these notices, or you might say to ensure that payee notices are not unduly found to be valid and the payer gets caught on the hook for a notified sum. And Coulson has called these consequences draconian, and then stated that if a contractor wants the benefit of these provisions, they are obliged to set out their interim payment with proper clarity. And he's added that the employers must be given reasonable notice. So construed generously, I think the court's approach as it's unfolded and as we're about to look at has tried to ensure clarity for payers when they're receiving applications for payment and to ensure that they're given proper notice. But I think it's really made a quite confusing situation, which is quite hard for general commercial men and women who are out there operating the contracts to actually understand what the requirements are. And again, we have Aikenhead here saying that an application for payment must be free from ambiguity due to the potentially serious consequences flowing from it. And I bring us back to the 9 principles set out in advance and an ESCA. And if we look at these, we can see that the first 3, which I've grouped together, are really a restatement of the reasonable recipient test, which we know exactly where it comes from. We then get the court stating that it will not be impressed by artificial or contrived arguments, which again seems fairly uncontroversial. But then we get an indication that a pay less notice might be construed more leniently than an application for payment, or payers' notices might be construed more leniently than payee notices. And there's no authority for that in the case, so in the earlier authorities or the earlier case law, and there's no reason for that in the Act either. So we're going to have a quick look at that. We then get a statement that notices and applications for payment must be in substance, intent, and form applications for payment or payment notices. And again, the question we have to ask ourselves is, where does this come from? And we're going to look at that shortly. And finally, the 9th point here is the agenda for adjudication test, or that a notice must provide an adequate agenda for an adjudication as to the true value of the works to be valid. And we'll look at where that comes from as well. And as I say, this leads to these 3 key questions. Are all notices created equal, or are there different tests? What is substance, intent, and form? Why do we have it, and where does it come from? And the agenda for adjudication test. So Coulson, in his practitioner's guide or practitioner's textbook, states that there has been a suggestion that payee notices are construed less generously. This doesn't seem to be consistent with Mannai, which states that there is a general class of unilateral notices and provides no basis for distinctions drawn on the basis of who's given that notice. And again, there's no distinction in the Act, or no reason in the Act that a payee's notice should be construed more rigorously than a payer's. Yet, in Surrey and Sussex, Nissen, QC, who was sitting as the judge, has accepted that the authorities provide some support for the proposition that a pay less notice should be construed more generously. They do, but only authorities coming after 2011, and none of them can refer back to any earlier authority. So this is entirely a phenomenon that we see grow after the 2011 amendments to the Act. Now what we see, on the other hand, is some really rigorous language being applied to applications for payment or payee notices. So we've got Aikenhead in Henier and Beck saying an application for payment must be free from ambiguity. And Nissen in Surrey and Sussex again saying that there is a high threshold for a payee's notice. And I invite you to contrast that with the language used by Coulson in his book, which is a first-class authority on adjudication and the payment provisions, where he states that provided that a pay less notice is tolerably clear, the courts will not strive to intervene. Now, to my mind, there's a big distinction between free from ambiguity and tolerably clear. And so this gets addressed in Grove and S&T. And when I say Grove and S&T, this is the High Court version of that case, which was heard by Coulson in the High Court, as I say, as he was at the time. And Nissen was QC, was counsel, and he contended that a pay less notice should be construed more leniently, consistent with his own judgment in Surrey and Sussex. Coulson states, actually, that the court should apply the same approach when construing all notices, which seems to clear the matter up, other than he then immediately says that the particularly adverse consequences flowing from a payee notice are relevant to the test of the reasonable recipient. Unfortunately, he doesn't tell us how they are relevant to that test. He only tells us that they are relevant to that test. I might, if I was being facetious, say that the relevance to the reasonable recipient test is, given those draconian consequences, the reasonable recipient would be extra alert to any communication they may receive from their payee. So there should be a lower bar for payee given notices, which is obviously completely out of kilter with the previous case law. But I think it highlights the difficulty with the compromise that Coulson is trying to make. We'll now have a brief look at substance, intent and form. Again, words that I think many people in the construction industry are familiar with, and indeed many of us will know that it comes from Hennier and Beck, where Aikenhead states that an application for payment must, in substance, form and intent, be an interim application. How do we get there? Where does that come from? Well, he doesn't tell us. Aikenhead doesn't give us an authority on which he relies or cite a previous case, but he tells us that an application for payment should be considered in the same light as a certificate. I don't know why, but that is what he says. And if we come on to Jalby Properties, Carr gives us a little bit more help because he states that substance, intent and form have often been repeated in the authorities. And he cites two cases. We've got Minister Trust Limited and we've got Token Construction. Both of these cases concern certificates and not notices. The first one concerns a certificate issued by a third-party engineer, essentially as to the quality of agricultural hardware. And the second one is a certificate issued by an architect. And where they talk about substance, intent and form, Davies tells us that a certificate has to be that in substance, intent and form because it is the physical expression of the certifying process. And what I would suggest is the certifying process, where you have a third party, as we do in some construction contracts, but by no means all, issuing a certificate, there is a duty of reasonableness. There is a duty of impartiality. And therefore, to be able to be seen to be discharging that, it is important that the certificate shows how the end number was arrived at. But I would suggest that is different. Sorry, let's not go forward. Let's stay where we are. I would suggest that that is different to a notice. The purpose of a notice, and this is set out in Mannai, is simply to inform the other side. For example, if we go back to the circumstances in Mannai, it was to inform the other side that you had chosen unilaterally, and it's a unilateral document with effect, that you were going to terminate your lease. Therefore, in my mind, there is a distinction to be drawn between a notice and a certificate. Now, you might say that in some construction contracts, we have certificates, even if they're called payment notices, they're issued by a third-party certifier, and I would agree with that. But that is by no means all, and I would suggest not even the majority of construction contracts. It's the majority of main contracts, but subcontracts habitually have one party issuing a payment notice to the other party. So I'll leave you with the question, and something to think on is, are the requirements of substance, intent and form derived from cases relating to certificates relevant to notices? We now come on to the agenda for adjudication test. Now, in Advance and Anesca, Smith tells us that the agenda for adjudication test, and I'll remind you, is that test being, does the document or the notice provide an adequate agenda for an adjudication as to the true value of the works? Now, this first comes up in Hennier and Beck. There is no direct or literal interpretation of the Act which will lead you to the reasonable recipient test. There are no requirements for it in the reasonable recipients test. But what Aikenhead tells us is that one of the things that we have to be mindful of is the need to establish an agenda for a speedy adjudication. And that's why he applies this test. Now, the interesting part about it is that he applies the agenda for adjudication test to a pay less notice, but does not apply it to an application for payment. And I would suggest that that makes perfect sense, because an application for payment is not immediately amenable to this sort of test. What do I mean by that? Well, an application for payment just sets out the sums that a contractor wishes to be paid. there's no guarantee that any or all of those items within that application for payment are going to be disputed by the other side. So there may well be no adjudication or no dispute to refer to adjudication regarding the application for payment. On the other hand, a pay less notice, by definition, there was a sum which was the notified sum, calculated including various items, some of which will not be paid. And it is only proper that the party not being paid those sums know what they are, so that they can then start their adjudication. So in my mind, and I would suggest to the room and those online, that while this test might suit a pay less notice, it's not a test to which an application for payment is amenable. And as we've already looked at, the same test should be applied to all notices. If it won't work for one, it can't work for any. And therefore, I would suggest it's an inappropriate test. Now, we have seen a development, and I haven't got the case on here, but we have seen a development in this test. I don't think I've got the case on here. No, I don't. But this gives us some of what I was talking about. If we go forward one slide, that gives us some of what I was talking about. I've got ahead of my slides. There was a suggestion that the agenda for adjudication test is another way of reformulating the requirement to specify the basis on which the sum considered to be due was calculated. I think that gets a square peg into a round circle. I don't think it really advances things any further, but it gives it some basis in the Act at least. And that does come from a case which I haven't included in here, but it's worth having in here. But ultimately, if we go forward one slide, to summarise the position on the agenda for adjudication test, it isn't founded in the Act. There's no basis in authority beyond what the House has beyond what the High Court has said, and indeed it appears to be inconsistent with the House of Lords decision in Mannai. And I would submit it's not relevant to applications for payment. Which all leads us to the Court of Appeal, and the most recent, and the Court of Appeal, the highest authority on this, certainly in recent time. And it was Sir Rupert Jackson giving the leading judgment. The first thing he does is he reiterates the relevance of Mannai when interpreting notices. And this is slightly interesting because a lot of the earlier cases apply to principles but don't actually cite Mannai. So it ensures that it tells us yet again that Mannai and the reasonable recipient test is at the heart of what we should be looking at when we interpret these notices. What Sir Rupert Jackson doesn't do is he does not mention substance, intent and form. He does not mention the agenda for adjudication test. And he does not mention that a pay less notice or payer's notice could be construed more leniently than an application for payment. He doesn't tell us why he omits these tests, but I submit that that wasn't a mistake. It's unlikely to have been an oversight. And it's particularly unlikely to have been an oversight because these arguments were all addressed in the High Court decision by Coulson in the same case. So these arguments were before the court, and Sir Rupert Jackson opted to not rely on any of them. In my opinion, what he was doing was, subtly at least, guiding us towards what the right way or the better approach to interpreting these notices is, which is just to rely on Mannai and the reasonable recipient test, and not to bring in these new and novel tests which have been proliferated since the 2011 amendments to the Act, or 2009 amendments which came into effect in 2011. But as you can see from the slide that we saw earlier, we still have many of these tests. And as you will note, Advance and Anesca is 2022, so it's 2 years after S&T and Grove and Sir Rupert Jackson's judgment. So despite the fact that many of these tests did not appear in Sir Rupert Jackson's judgment, they have been kept with by the courts in the High Court. I'm now going to just briefly touch on 2 recent cases before we move on to look at the role of contract requirements very quickly. So the first recent case is Place First and Car. Now, I'm not going to talk about this in great detail for two reasons. The first is we had a wonderful exposition on this in our previous talk up in Oxford, which is available on YouTube for anyone who missed it. So it's there, and our speakers on that occasion gave us a great exposition of this, so we don't need to go into it in any detail. But also, in this case, they never really wrestled with how to interpret notices or the applicable law on the interpretation of notices. What they do is they do highlight the importance and endorse the summary in advance and an ESCA. In fact, the two cases from this year on payment notices both highlight the importance of the summary in advance and an ESCA. So even if you think I'm talking rubbish and the High Court's got it all completely right, and you might well do, the one thing I would take away is that the summary given in advance and an ESCA is really worth reading as the current position, and that's highlighted in this case and the one we're going to look at shortly. Now, the pay less notice was deemed in this case to comply with the requirements for the Act. The interesting point in this case was the timing of the pay less notice, and just to highlight what that is, the pay less notice in this case was given before the final date at which a payment notice could be given, but after an application for payment had been made. Now, many of us previously felt that that would render a pay less notice invalid because there was no notified sum at that point. The court said that's absolutely not the case. And what was held was that as long as, and this is important, a pay less notice must be given after an application for payment, but it can be given after the final date for giving a payment notice. So what it's saying is that an application for payment has effect.
It can be given before final date for giving of the payment notice. You said after.
Yes, that's what I mean. I mean, it can be given before the final date for the giving of the payment notice. Now, what is interesting here is that at paragraph 64, there is an indication that you can have an application for payment, after which you issue your pay less notice. If that is before the final date by which you can issue a payment notice, the indication in this case is that you can then issue a payment notice after the pay less notice. And then you may be able to issue a subsequent pay less notice. So two pay less notices within one cycle. I think it's ripe for causing confusion and would do well to be looked at once again. And there may well be an appeal, I think they indicated in our last talk, and it'd be interesting to see how that's dealt with if there is an appeal. But I leave that with you there, but it just tweaks what many of us thought previously was the case, and certainly worth being aware of. The other thing I'll highlight from this case is that it was held that when read in the context of the Act, the contract, and the context of how interim payments are commonly dealt with, the payment notice was sufficiently clear. Two things I'll highlight there. One is the term sufficiently clear. Again, I'll invite you to contrast that with the requirement for an application for payment to be free from ambiguity. There's definitely a difference between that and sufficiently clear. But the other thing I thought was interesting was that we know from Mannai that the reasonable recipient test is to be applied taking cognizance of the relevant contextual setting. Well, in this case, we're told that the relevant contextual setting is how interim payments are commonly dealt with. I'll leave you to draw your own opinions or have your own thoughts on how interim payments are commonly dealt with in the construction industry, but I would suggest that the way that they're commonly dealt with in the construction industry is not a model of clarity. And if that's what we're to be taking into consideration, that might be a substantial lowering of the bar. I don't think that was what was intended in this case, but I wouldn't mind putting that in front of an adjudicator once or twice. And we have a second case, which is JV Homes. Now, this really only has one important takeaway. Well, two important takeaways, I'll give you that. The first is, again, that reiteration of the importance of the summary in advance and an ESCA. So I can't say it enough, but the summary in advance and an ESCA is the statement of the current law. If you want to know what the law says on this, you could have saved yourself 45 minutes listening to me and just gone and read the paragraphs there. But that is highlighted there. The second point is we had invoices issued from a contractor and the question was, did they provide sufficient detail to be valid? And what I've done is, if you go back one, sorry, this is an extract from the judgment. I've got it here, it's paragraph 139. The judgment actually sets out the invoices. And what you'll see here is one of the invoices. And you'll notice that there's no breakdown to the sum claimed. There's a description, we'll see here, there's a description of the works which it purports to relate, or to which it purports to relate, with no breakdown or calculations. Before this case, in my opinion, I would have suggested that you need some breakdowns to those calculations, perhaps to show in my mind, to show the basis on which a sum considered to be due was calculated. You would need some calculations. You would need some breakdown. That wasn't the case. This was held to be a valid notice and was enforced. So again, it's just a recent case bringing you up to date. It's an interesting quirk, which might be different to what you'd previously thought. And again, might be useful to anyone running an adjudication on behalf of a contractor. So, contractual requirements. Bear with me, there's only 2 slides on this, but I think these are quite worth looking at. So the first point here is a statement of the law. And we looked at this previously, and it's fairly uncontroversial, but a notice cannot be valid unless it gives the precise notice which the contract requires. So we'll cure minor slips, but if the contract says you have to give it by a certain time, you've got to give it by that time, hard and fast. That was illustrated by Lord Hoffman in Mannai, in which he said that if the contract requires a notice to be on blue paper, it would have been no good serving a notice on pink paper. The point being, it's a capricious requirement. There's no benefit. It doesn't help you understand it, having it on a certain colour paper. Potentially, maybe it would. Doesn't matter. If the contract says you've got to do it, you've got to do it. But we have Kersfield Developments. And Kersfield Developments uses the JCT Design and Build 2011, and all the relevant clauses are materially unchanged in the 2016 edition. Now, I haven't looked at the 24 edition, so you'd do well to look at that, but I don't believe it's changed. And we had Cameron Kirkham here not long ago, and there was certainly no mention of this changing, so I believe they're the same. Now, this contract required an application for payment to be accompanied by further information specified in the employer's requirements. This could be anything. In this case, it was breakdowns, it was evidence of costs or works done, those sorts of things. But potentially an employer's requirements could include anything that has to accompany an application for payment. Now, the interesting point here is that the application for payment was held to be valid despite the fact that it was not accompanied by those documents. What the court says is that the contract did not expressly provide that applications are not valid if they do not contain the supporting information. Now, to my mind, I think the language accompanied by is relevant here. It doesn't say it forms part of the application, but it's submitted alongside with. And I think because of that, that is part of the language which persuaded the court that the application for payment could be valid without the supporting information. But it's also reminiscent of condition precedent clauses where you have to state expressly that unless accompanied by or unless submitted with this supporting information, it will be invalid. And the court simply held that the employer's remedy was to issue a payment notice. So that's just a brief overview of where the law is with regards to contract requirements. And if you're going to have a requirement in the contract requiring additional information to be served with an application for payment, you need to be explicit that the application for payment will not be valid unless it's accompanied by those documents. And that brings me to the end. So you've got my LinkedIn on there, so please feel free to connect and connect with me on LinkedIn. Happy to answer any questions there or any questions anyone may in the room or have online.
US, but you made some very
repeated questions, right?
do we have to do this online? Yeah, actually, I was going to make a point, but it is relevant to what I do. You made sort of a lot of things about notices, leases, I understand quite well. And notice is a general thing. So what applies to your lecture would apply to notices, including party ward rules, I guess, and that's important. Serving notice, is that a truism? Is that true? That, you know,
well,
I
think
about the status of a notice.
Well, I think what I would highlight.
It has to be clear and these other things.
Well, some of these things do, and some of them don't, and that's somewhat the point I'm making. Mannai applies to all unilateral notices in commercial contracts.
Yes.
So if it's not a commercial contract, there might be something different. I don't know about that. But if it's a commercial contract, the reasonable recipient test applies. Absolutely, unequivocally. I'm not going to talk about party ward awards specifically,
no,
but yes.
James, you need to question. Yeah, people online won't be hearing it.
Understand. So the question in the room was, to what extent do the principles that we've discussed this evening relate to notices other than payment notices under a construction contract? And the response to that is that really, and I've looked at other notices, such as notices of dissatisfaction, which are given after an arbitration or other types, leases, and those notices, the High Court will still apply the reasonable recipient test. What they don't do in the courts is bring in all these other tests. So they don't bring in substance, intent and form if they're looking at a notice of dissatisfaction. They just apply the reasonable recipient test.
And you did make an important point about, I think there's a world of difference between certifying something, giving notices of one.
Absolutely right.
Yeah, I think you agree. So putting them together is, you'd have that very good. No, I think they're very different things. And I think that's your point, isn't it?
That's exactly my point. I can see how you would get there in the context of a payment notice, because you go, well, it's a payment notice. Often under a payment notice, it's given by the architect or contract administrator. It's a certificate in that circumstance. But that is only a small percentage of all payment notices given. And that's why I think conflating them was a mistake. And I agree with you, they're certainly different things.
Question?
Oh, online? Yep.
Yep. Sorry. The question is, it's from Kevian Daunt. When you issue a payless notice, should you reassess the value of the works previously notified under the payment notice at the later date of the payless notice?
Well, that's a really fun question, because the Act tells us that a payment notice should specify the sum due at the date, sorry, a payless notice should specify the sum due at the date at which it's given, which does indicate that you might reassess it at the date it's given. I haven't got the case to my fingertips, but my understanding of that, of the law on that currently, is actually, well, it varies on the contract, but if you look at the JCT, it tells you that you value the works, I believe, at the interim valuation date. So it's still that valuation at the interim valuation date that applies, less whatever you're deducting, okay? So no, you don't reassess it under a JCT in particular. You don't reassess it at the later date. You use the date as per the contract, stating, because the contract states that the sum due is the sum of, or the value of the works calculated at the interim valuation date. That hasn't changed to the pay less notice, but you would calculate any deductions potentially to that pay less notice date. I fumbled that a little bit, but I hope I got the point across.
James, you and I know that we've had this conversation before, because if you were going to have a notice that sets out information to be the basis of an adjudication, then you'd expect there to be some granularity within that notice. In other words, you can see the sum that's going to be due and how it was calculated. If that was the case, then the issuing of an architect's payment notice, which does not show how it was calculated, technically is invalid unless it's got the QS's build-up attached to it so that the recipient can see how the calculation was formed. So we've been going on for many, many years saying an architect certificate is a valid payment notice. But if you go through the case law and follow it through, there's an argument to be made that it is invalid because it does not break down how the sum was calculated.
So what I think you're referring to in particular is if you were to look at, for example, the standard format for a payment notice on the RICS website, but there's lots out there, lots of places do these standard certificates. What they will usually set out is various information around the contract, so you know to which contract it relates, the gross valuation of the assessment, less retention to get a net sum, less previously certified to get a sum considered to be due. The question is that on its own sufficient to be a payment notice? I've had an adjudicator agree with me that it is not in a recent adjudication. I'm sure there would be some adjudicators around the world or around the country who would disagree with me and say it is. I think I agree with Mark. I think that it would always depend on the circumstances and exactly what was done, but it's likely that a certificate on its own does not sufficiently specify the basis on which the sum considered to be due was calculated, and that you would need some backup showing how the gross valuation was calculated to discharge that requirement. I think there's two follow-ups there, so we'll have the one in front and then the one in the back.
So how could it be argued otherwise? You've just got very, very basic calculation with no substantiation.
Yeah, so the question is, how could it be argued otherwise? So you're asking, how could you argue that it's valid?
For example, if the contractor applied for a sum of 200,000 in a month and the architect certified 50,000, that is in no way an explanation.
I would agree with you. I would agree with you.
James,
The
sorry.
question was, how could it be argued otherwise?
Yeah.
Well, I suppose one thing I would take you back to, and I'm going to forget the language. Where is it?
Which one?
The context of how payment notices are commonly dealt with. And I would say that they're quite commonly dealt with by people issuing just a certificate and no backup. I've seen it. I'm sure others have as well.
Yeah.
I'm in no way advocating for that. I think that's poor practice. And even if that didn't render it invalid, or you might win the adjudication, you're putting yourself out on a limb that you just don't need to. And it flies in the face of the Act, because the Act is there so that a contractor, as a bare minimum, understands why they're not being paid the sum applied for and can do something about it. So I agree with you 100%. It's not an adequate agenda for an adjudication. It doesn't sufficiently specify the basis on which the sum considered to be due was calculated, and it should be invalid. Sorry, there was a second one. That's interesting. If the contract, the question is, if the contract only stated that only a certificate is required to be issued. Now, in terms of do you comply with the contract, tick, it's a valid notice. Now, the question is, does the contract comply with the Act? Because the Act requires, so it comes from the Act that a notice must specify the basis on which the sum considered to be due was calculated. So if you've got a contractual provision which says you don't need to specify the sum considered to be due, that seems to me to be in conflict with the Act. So potentially you might run into a problem there. I would still personally issue some substantiation or some build up to it, just to be safe, really. But yes, in theory, for example, if it was a contract with a residential occupier, which isn't caught by the Act, I think you'd 100% be all right. If it's caught by the Act, you might not. Sorry, Eddie.
So we've got one from Christopher Ennis. But if the payment notice refers back to a separate calculation for an earlier payment notice notifying exactly the same amount, is that sufficient? I held that it was.
And I think you are probably right. Fortunately, it wasn't against me. No, I think that you're probably right, because we are told in the cases, and again, I haven't included it in what I've done today, but we are told in the cases that you can absolutely incorporate calculations by reference. There's no controversy there. So yes, yes, by reference to an earlier notice, I think you've incorporated it by reference, you've got the calculations in, or by reference to an earlier circulation of calculations. So for example,
So just leading on to that, I thought it'd be pertinent. There's another question from Kevin Daunt. If certificate was only referenced back to the valuation as opposed to attached, would that be invalid?
yeah, so I think we're all on, these things are really on all fours with each other in the sense that you can incorporate by reference. There's definitely case law on it. As I say, I apologise for not having it at my fingertips, but there's definitely case law on it. You can incorporate by reference. So as long as you say, I reference this earlier certificate, and it's clear what you're referencing, you must be crystal clear to what you're referring, or you say, as per, if you were the contract administrator, for example, and there's a different quantity surveyor, as per the quantity surveyor's calculation of the sum considered to be due in an earlier email, then I think absolutely it's incorporated.
I think just what you just said there, James. So Matthew Thorne has commented that was the issue in S&T versus Grove. The contract administrator said it was okay to incorporate by reference to earlier notice.
Definitely. I think there's an earlier case as well, but definitely it was caught up in S&T and Grove, or Grove and S&T as well. So thank you very much. Any more? Brilliant. Well, thank you all very much for your time this evening, and I'll hand back to Mark.
So, probably he doesn't thank himself. I'd like to sort of dip in again and say, James, thank you very much indeed. Look, there's a lot of technicalities in there. This is complicated stuff. The very fact that you're able to find nuances and differences between high court cases just shows that this is a bit of a, it's still a moving target, but it's fascinating. And for those of us who are a bit nerdish, we love this stuff. So, James, thank you very much indeed. That was an absolute tour de force in a very, very quick time to get through that in 45 minutes when he could have been talking about it for hours. If I could ask you again to show your appreciation of David's